This is for your info shit, y'all. They keep blocking and banning my accounts because of the stuff that I'm talking about. It's real deal. Holyfield. You feel me? No jokes, no games. And so I got to double back for the 9th time to tell y'all what's been going on with me. And this particular case right here, I got several other cases that I'm dealing with too. And again, this video is for educational purposes only, and it's also for informational purposes, and it's also for the people that it pertains to, you dig? All my Indianians, because I'm coming out of South Bend, Indiana, St. Joseph County, y'all. And I've been telling everybody about this case. It's carrying a handgun without a license that I've been battling since 2017, y'all. And this case involved an officer by the name of Hunter Allen Miller, who committed perjury in my trial, y'all. Let me see, I got sentenced, January 21st of 2020, y'all. In which I got sentenced to like 6 months of non-reporting probation. And they destroyed my firearm, y'all. In this case right here, carrying a handgun without a license, St. Joseph County. And y'all, what I'm showing y'all, these are the trial court transcriptions from the hearing, y'all. Now, y'all, this situation, the officer was driving my car, right? Before he drove my car, he never seen a firearm in my car. He never seen a firearm before he got into the vehicle, put his seatbelt on to drive the vehicle, put the vehicle in drive. None of this, right? But in his police report, he reported after he arrested me that the handgun was in plain view sight. That's what he reported in the police report. But, like I said, it came to a point in time where the officer did get in my car. Like I said, he opened the door. He never saw a gun. He sat in the car. He never saw a gun. He put the seatbelt on, and he never saw a gun coming out of the armrest or, protruding, as they say. And he put the car in drive. He drove the car around the block. He never saw a gun. Like I said, y'all, as Hunter Allen Miller reported, as he put the vehicle in park is when he noticed a handgun in the open center Plainview Council. That's what he put. He said it was open center Plainview Council, right? So remember, I just told y'all all the stuff he did before he drove the car. While he drove the car, he never saw anything open center Plainview Council. And also I want to add, this was a day before my birthday, 10/21/2017, y'all. I had a big ass half gallon of Grey Goose in my driver's seat. When he opened the door, the half gallon was sitting in the driver's seat, y'all. So in order for him to operate the vehicle, he had to move the bottle. You see what I'm saying? In which if he moved the bottle even up against the armrest as he claimed he did, or if he moved it over into the passenger seat, either or, he never saw a handgun open center Plainview Council. And this is what my attorney was basically saying. But my attorney got him basically on him saying he never touched anything in the car. But the first hearing he took, he said he moved a bottle towards the open center Plainview Council to operate the vehicle. That was in 2018. 2019 comes around. He says he never touched anything in the vehicle. He just seen the gun open center Plainview Council. And that's straight bullshit. And that's what my attorney said in the transcript. He said, Officer Miller, you testified you didn't move the bottle, correct? The officer said, correct, y'all. My attorney said, do you remember doing another hearing that you were under oath previously in this case? The officer says yes. My attorney said, do you remember testifying in that hearing that you, Mr. Wandling, may I approach? The court says yes. Now, Mr. Swaby is the deputy prosecuting attorney. He said, may the state see or approach to see what Mr. Wandling is referring to? The court says sure. Mr. Wandling, my attorney, he said, so you were under oath during that hearing, correct? The officer says yes. My attorney said, you were the one questioned during that hearing, right? The officer says yes. My attorney said, you were there for the whole thing, correct? The officer says yes. My attorney said, so an answer would be you, right? The officer says yes. The officer says, what is this indicating? My attorney said, this is I don't know if the manuscript is the correct word to use, but this is transcript. The officer says transcript. My attorney said, of that hearing, right? The officer says yes. My attorney said, can you read from line 2 to 15, please, for the jury? With the Q's and the A's? The officer says, that is where it was approximately where I got into the vehicle, even the bottle when I got into the vehicle, so I could operate the vehicle without it falling over and spilling. I didn't want it to spill in his vehicle. My attorney said, so where did you move the bottle to? The officer said, I believe I moved it kind of over just to the side a little bit, just a little bit. My attorney said, so you sat on the bottle? The officer said, no, I tucked it over to the side a bit so I wouldn't sit directly into it. My attorney said, so you moved it towards the console when you got in, is that correct? The officer says, yes, more towards the seatbelt buckle right there. My attorney said, thank you, officer. The officer says, yes. Mr. Wanling says, move to admit defendants too. The court said, is it the whole thing? Mr. Wanling said, the whole thing. The court says, approach. Now look, y'all, the deputy prosecuting attorney, he says, is this impeachment? Look at that. This is in the trial court. The court says this is being offering for impeachment purposes, not as substantive evidence, y'all. Look at that. Can anybody tell me out there, any of you top lawyers with the bar card and all that, let me know what offering for impeachment purposes is. I never heard of that. I thought impeachment was impeachment or perjury was perjury. And a lot of y'all gonna say, well, it's perjury. Well, this is what they put in the transcript. So I'm just saying what they put on record. So yeah, his impeachment was taken as impeachment purposes, not as substantive evidence. This is by the officer. So the officer has just committed perjury right off the gate. And the court says, well, we don't need it admitted then. You see that? Because the judge, Jenny Pitts Maynier, knew that Hunter Allen Miller was lying, as well as the deputy prosecuting attorney, Robert Michael Swaby, knew that Hunter Allen Miller was lying as well. Again, y'all, I'm just simply reading from the trial court transcription. I paid for this. You see what I'm saying? So these is all facts. And this is my situation, what I am still currently going through because I'm trying to get this overturned. And I went through many channels, y'all, and they are ignoring and disregarding my documentation in regards to this because they know that this is what you call fruit from a poisonous tree. Because again, if the gun was open center plain view counsel, as the officer reported, he would have saw the gun immediately getting into the vehicle. You see what I'm saying? Immediately opening the door, you would have saw a gun open center plain view counsel with several other officers on the scene. And Hunter Allen Miller also was being supervised. He had a training field officer this day by the name of Joseph Galea, y'all, of the South Bend Police Department, who put me in handcuffs. Joseph Galea did, and told me that the reason I was being arrested was because I was a big fellow and it was for my safety. That's what you told me, Joseph. We can run it back now because I don't got no reason to lie. But anyway, my attorney says, so Officer Miller, that testimony is different. That testimony was June of 2018, correct? The officer said, correct, y'all. And my attorney said, and we're in September of 2019. The officer said, correct, y'all. My attorney said, and in that testimony, you said you moved the bottle towards the center console. See, my attorney should have said, you moved the bottle towards the open center plain view counsel, because that's what he reported. And the officer said, I did. And my attorney said, and today you said you didn't? And the officer said, I did, y'all. And my attorney said, both times you were under oath? And the officer said, I was. And my attorney said, and those are diametrically opposite statements, aren't they? And the officer said, yes, they are. And my attorney said, both of them cannot be true, can they? And the officer said, no, y'all. My attorney said, and since there's two statements that you are providing that are, one of them has to be incorrect, correct? And the officer said, correct, y'all. So we already got him lying, and he admitted to it. You see what I'm saying? And this is in the trial court transcription of that hearing that day, y'all. And this is even from the sentencing hearing of January 21st. I want to show y'all my attorney was even pissed, y'all. He said, the factor that the officer got on the stand and lied and committed perjury. One thing about it, a public servant and perjury should not be in the same vicinity or in the same documentation. Should be weighed into the consideration in the sentencing. And that was Michael Wanling who said that. So big ups to you, Michael, for that. You gave it a whirl, man. You could have did better, but this system in Indiana is so fucking racist and corrupt, bro. I'm gonna tell y'all more about what I've been doing in today's time in regards to this, but I'm just giving y'all a brief snippet of where it all stemmed from.